My name is John Mejia. I'm the legal director of the ACLU of Utah, and I'm here to talk about the case of State versus Valdez that raises a very interesting and novel question under the Fifth Amendment. So in this case, there was a criminal defendant who had been asked by the police to provide his passcode. In fact, the police had a warrant for that passcode. And in exercising his Fifth Amendment right to remain silent, the defendant had refused to give police their passcode. So during the trial court allowed the prosecution to argue at closing that the jury could imply that the defendant's refusal to turn over the passcode meant that the defendant was guilty. And so the important question there is sort of, in this digital age, can the state compel us to turn over very sensitive information that we store on our phones, and can our refusal to do that be used to imply that we're guilty? And this is sort of a novel case. Technology often advances much quicker than the law, and we think it's really important that the Supreme Court of Utah uphold the Court of Appeals, because these are a cell phone contains so much personal and sensitive information, and our refusal to give that information to the government should not be used against us. So the ACLU is involved in this case. We, along with our partner organization at the Electronic Frontier Foundation, have filed a friend of the court brief arguing that Utah should follow other state courts in finding that the state should not be able to argue that refusing to hand over sensitive personal information can be used to imply guilt.